Hi, this is Rahul Reddy. I'm from Reddy Neumann PC. Thanks for coming in and logging in. Along with me is my colleague Paloma Fegali. She's an associate attorney with Reddy Neumann PC. Our law firm has been established in 1997. We do mostly business immigration. We bring in live from Houston, Texas every week on Tuesday at 5 Central Time. Paloma?
Thank you for joining us on Facebook and YouTube Live today. As Rahul mentioned, I'm Paloma Fegali and I'm an attorney at Reddy Neumann PC. So we'll get started on our topics today.
Today Emily has some family emergency. She couldn't be here, so Paloma is filling in for Emily. Paloma, we're going to discuss mostly what people, the hot news that are coming up is the notice to appear, which the administration said they're going to delay it. We're going to discuss about the per country quota limit. We're going to also discuss about the IT company owners that got arrested recently on fraudulent H-1B filings. We're going to work on the issues that are about the STEM OPT third-party placement, whether or not individuals can work at third-party placement. Those are the things that we're going to discuss. Also, on the September 11th, we're going to have the new memo kicking in where the USCIS might deny the H-1B applications if there is no RFE. So we're going to discuss about that too. And also on August 8th, there's a new memo going in with regards to the illegal presence of the CPTs and STEM extensions.
Right, so the first question we'll go into is what is the HR 392 bill?
The HR 392 is a bill that is presented in the House. However, due to the lack of the consensus in the House, they have presented it as an amendment in the Department of Homeland Security Appropriations Bill. We're expecting that the Department of Homeland Appropriation Bill to go through, but there are a lot of hurdles that are expected in the Congress. As you know, Paloma, that the USCIS has not passed any major immigration bills in the past 30 years. In this Department of Homeland Security Appropriations Bill, they did have a lot of things attached to the bill, including the issues of the removing the lottery system for the lottery visas, eliminating some of the family-based immigration issues. So it's going to be very hard for this bill to be passed. The chances for this Department of Homeland Security issues to go through, appropriation bill go through, seems to be very rare though. Mm-hmm. But just to explain to the audiences, what is HR 392 is that there is a per country quota limit that is prohibiting the Indians to get the green card. If the per country quota limit is not there, the waiting list for the Indian nationals would have been 3 years. Because per country quota limit is there, the waiting list is right now about 11 years, but is expected to go about 150 years. We're expecting that if the 392, whether it goes through the Department of Homeland Security Appropriation Bill or by standalone itself, the priority date will come to 2013 from 2009, and probably in the next year it probably will come to about 2016. So that's very good for a lot of Indian nationals, but the chances for this to go through in this bill seems to be very rare.
Okay, so the next thing we'll talk about is I recently saw in the news that some IT company owners were arrested for visa fraud. What should employees watch for when selecting an employer to sponsor their H-1B?
Yeah, this is a big thing that went on. Approximately 14 companies have been under investigation for a long period of time. They have taken into custody about 5 employers in the past 1 week. They're expecting that network of operation to spread around to about 14 companies. Well, one thing the employees need to watch, Paloma, is that if they are paying money for the companies to do the H-1B, that's definitely a big no-no. And if they know that the companies are filing H-1Bs where there is no in-house project and they're filing with an in-house project, that is a big no-no. And a lot of times when what we see is that there is no end client, there is no project, one consulting company gives the employer the end client letter to another consulting company gives an end client letter to another consulting company, and there's actually no job there. And because of this reason, where there is no job and the people are giving the end client letters when the job does not exist. The investigation went on, and that's the reason why these people are getting arrested. So if you are contacting an employer who doesn't have a job and he's filing an H-1B for you, that is a big no-no. If you don't have a job, the employer should not be filing. If they are filing the H-1B when there is no job, that's definitely a good indication that there is a fraud in there.
Okay. So our next topic is, so USCIS has updated its rules for working on OPT STEM extension. What should those working at a third-party site do at this time?
STEM extension people have issues. STEM extension people, as you know, Paloma, what happened was that previously they were allowed to work at third-party location. In January of 2018, USCIS all of a sudden changed their policy with regards to whether a person can work at a third-party site. They just updated the system. That's not there in the rules. That's not there in the regulations. They did not issue a memo. They just passed, they just changed the website. And we started seeing RFEs on the STEM extension based on the website saying that the individual, why is this individual working at a third-party site when the website of the USCIS is telling that they cannot work at third-party site. We're also noting some of the universities requesting the employees to not work at third-party site to update their 983s. We have also seen in some cases where the DSOs have stopped issuing the 983s when the person is working at third-party site. We are expecting more problems coming forward on this 983, particularly if you have been issued an RFE on the 983 and you, on the issue when you file the H-1B, they have issued that saying that on the STEM extension you're working at third-party site. You may want to discuss with your lawyer to see if you actually want to file an H1, you want to convert your H1B to a consular processing, because the consular processing will avoid the issue whether or not you are legally in the United States. But if you try to challenge the USCIS at this point of time, saying that the USCIS doesn't have the authority to rule because it's not there in the regulation that you cannot work at third-party site, it's not there in the law that you cannot work at the third-party site, USCIS has changed arbitrarily without giving a chance to the employees, schools, and students to allow to comment on the law change, and they have changed it unilaterally. If you challenge that, if the USCIS denies your change of status application, you might have a hard time getting the H-1B approval in India. Also, you also need to look forward to the August 9th memo that is kicking in, that if the person is out of the status for more than 180 days, they will be barred for 3 years to come into the United States. So it's a big gamble. If you get an RFE on the issue of third-party placement on the H-1B, I would request that you contact a lawyer personally to see if you want to go the consular processing option, or if you want to go with the change of status option.
Okay, so last week I know you and Emily talked a lot about the NTA, or notice to appear policy.
Yes.
And since then there's been a couple of updates. If you wanted to go into that a little bit.
What notice to appear, it has really caused more panic among a lot of individuals. We have noticed that a lot of rumors have spread around. As you know, Paloma, we had to issue a statement. My business partner, Reddy Neumann, has published an article that fake news on the notice to appear has been, we published in immigrationgirl.com. Now, notice to appear is a notice sent by the USCIS indicating the individual to come to the immigration court to defend themselves why they should not be removed from United States. Normally, this notice to appear is issued in very serious cases, but in the USCIS recently, what they said was that the USCIS recent, they could be issuing the notice to appear in any cases whenever the status has been determined to be illegal. That was not normal in business immigration. Mm-hmm. But with this administration, issuing a threat that they could issue a notice to appear has definitely caused a lot of panic among the individuals. From the beginning, Reddy Neumann PC has been advocating that I don't think so they're going to issue a notice to appear flatly to all the status denials. We did not expect that though. But right now, USCIS has come to a stage where they said they couldn't handle all these things, so they delayed the implementation of the notice to appear. At this point of time, there is no fear for you that the notice to appear will come if the change of status or extension of status has been denied. In most cases, in 99.9% of the cases, you will not be issued a notice to appear, at least right now. If there is any development that pops up after the USCIS issues any more guidance on that, we will update you. Have you seen any rumors flying around on that, Paloma, on the notice to appear?
So yes, I have seen, as you talked about, the fake notice to appears that are coming out.
Fake? What do you mean fake?
So people are posting actual fake notice to appears. So if you see photos of that and as of yesterday, USCIS announced that it's postponing implementation of the recently published policy memorandum. So those are the recent updates that we've received.
Okay. Well, be watchful. If you're getting a notice to appear, first thing is you contact a lawyer. And
Right.
as Paloma was pointing out, that people are just trying to create panic among the community by faking those news. So please be wary of those people though. Paloma, what is the trend on the RFPs and the H-1Bs? What was it last year? What is it different this year in the RFPs? You know that last year they were in the wage level was a major issue. There was a system analyst was an issue. What is the major issues in the RFPs that you're seeing right now?
So we're seeing all sorts of crazy RFEs, which are varying from all sorts of things, if you want to go into it a little bit.
Yeah, I mean, we have seen, Paloma, that if the end client letter is having a job description and the vendor letter having a job description, if the job letters are mirroring each other, we have seen a denial for that. In cases where the job description is a little bit away, the end client job description, the vendor job description is a little bit off, we have seen a denial saying that this is not matching with the other one. So it's kind of getting crazy on the consulting companies, seeing that denying the H-1B cases indiscriminately. So last year they were particular about wage level 1 and they were particular about system analyst. Right now they're particular about the end client letter, vendor letter, the contracts between the end client letter and the vendor letter. So if your end client is not going to issue if the end client is not going to issue the end client letter, the possibilities of you getting the H-1B seems to be very rare.
Mm-hmm. So the next topic we have is, so in light of the new USCIS guidance effective September 11th, 2018, should we be expecting more straight H-1B denials without RFEs?
The memo that is becoming effective, which came on July 13th, Friday, 13th of Friday is always a bad day in USA, came in, it was effective on September 11th, what a bad day to be effective anyway. What it pointed out was that the USCIS, at its discretion, can deny the non-immigrant visas if the proper documentation is not being filed. So what is a proper documentation? Now, according to the law, according to the regulation, there are certain documents that are absolutely essential to file a H-1B. For example, the educational documents, for example, the I-94, for example, the LCA. These are absolutely essential documents that need to be presented. However, now, when the education is not in United States, or when the education is not in the relevant field, not submitting education evaluation might be constituted as an essential document, and they might deny though. Now, Paloma, the question mainly comes is that, can they deny the H-1B when the end client letter has not been presented at the time of filing the H-1B? Can they deny when the vendor letter has not been filed, when the vendor letter has not been vendor letter has not been issued? I don't think so they can do it. That's my reading. Because when you look into the forms, when you look into the law, when you look into the regulation, it doesn't say that the end client letter is an absolute necessary thing. However, though, this administration is very crazy. You never know how they're going to act on. According to the February 22nd memo, February 22nd memo, the USCIS said that you need the end client letter, you need the vendor letter. However, in that February 22nd memo of 2018, they didn't mention that it's an essential part of the document. Now, so I think so that we might not be getting the denial straight away if we don't submit the end client letter. That's my reading. I might go wrong in it, but that's my reading at this point of time. If there are any developments that are going to pop up at a later time, we are going to update you guys as we are weekly. Every week we come in, we update you guys, we will. But at this point of time, I don't think so that if the end client letter is not there, they will deny it. Now, having said that, the February 22nd memo do point out that the end client letter, vendor letter is needed. So even though you might not be producing them at the time of filing the H-1B, if you don't present them at the time when your RFE is issued, there is a good chance that we might still get the denial. Whether they're going to issue at the initial level is a major issue. We don't think so, but we'll update you as the things move on.
Right.
Any questions from Facebook that you're getting?
Let's see.
Huh? Now we're going to go to the questions and from the Facebook, and we'll see some of the things. What options do I have if my H-1B transfer is denied the second time? Can I file again for the third time with a new employer? If your second H-1B, that means your first H-1B, either your extension or transfer got denied and your I-94 has already expired and you filed with the second company, you already got the denial, that would be a right time for you to leave the country. Because if you don't leave the country at that time and you're going to try the third time, the US consulate will not be that happy that you waited for the third denial and then you went back to your home country. Since you have an issue of getting the denial first time and you have a denial for the second time, I would not recommend you take any chances in United States. I would recommend that you go back to your home country and try your chances.
Okay, the next question we have is, has USCIS published a list of mandatory documents required to avoid a denial without an RFE? Is the list available? At this time, there's not any sort of...
Sachin has a good question though. Well, USCIS has not published anything where it's an essential documents at this point of time. But they do have the list of the documents when you go into the USCIS website, you go to the forms of the I-129. It's clearly mentioned that the educational documents need to be there. The LCA need to be there. If you are asking for a change of status, the I-94 need to be there. They also requested the education evaluation documents need to be there. So if you don't have the educational evaluation, when your bachelor's degree is, when your degree is not in United States, you might be in trouble.
Okay.
Day one CPT. Now this is a question that comes up all the time. What if the person have never used the CPT and continuing the academic education by transferring the credits from master's degree? Well, one major issue that we have in the day one CPT was that if and when you take the day one CPT, we are a bit worried why your day one CPT was being issued. We're having some technical issues here. Give me 1 minute, guys. So when the day one CPT, you have taken it, we are worried that not even if you have not used also, you might be in trouble. One reason is that when the day one CPT, the kind of colleges that are issuing the day one CPTs, we have a major problem with those day one CPTs. These colleges are not conducting classes. These colleges are not, I'm sorry guys, we're having some technical issues. Okay. So since these colleges are not conducting classes and we have some doubts with regards to the conducting of how these colleges are operating, we have a problem with any university that is issuing a day one CPTs. Any more questions?
Okay. So I'm on H-1B currently and in the process of switching my employers. Can multiple employers file my H-1B transfer petition at the same time?
Multiple transfer of H-1B applications can be filed at the same time. Absolutely not a problem. That will not cause any problem. Multiple filing of H-1Bs is a problem when you are applying in the new quota, but not when you are filing multiple transfers at the same time. We're going to end the Facebook Live, guys, because of technical issues. We're going to go to YouTube and we're going to post the same thing in Facebook later on. But keep posting the questions on the Facebook, so we're going to answer those questions, guys. Is it legal for an OPT STEM student to work at client site? Yes, it is perfectly legal for the OPT student to work at the client site. Though it is an issue that has been raised in the STEM extension level, but that is not an issue at this point of time in the OPT. No questions?
I'm not seeing any more come up since the disconnect.
Who is the best attorney in your law firm to help with the H-1B RFEs? I think so the best attorneys would, in our law firm that I would say is Stephen Brown, V. Hong, Zachary Taylor, Justin Rivera, Gabriella Cole, Sue. Sue is one of the other lawyers that are doing very good in the H-1B RFEs. Is it safe to file a H-1B to H-4 EAD concurrently? H-1 and H-4 and EAD concurrently? Yes, it's absolutely good to file an H-1B, H-4 and EAD at the same time. Not a problem at all. It's good. You can file it, you can still file it. H-4 EAD is still active. You can still file it. You don't have any problem in filing the H-4 EAD. We were expecting regulations on the H-4 EAD. But those regulations did not come up at this point of time. They've been delayed. So you could still file the H-4 and H-4 EAD at the same time.
Okay, do we expect the HR
392
soon?
I hope that HR 392 is passed in different formats. It could be passed, I hope, but the realistic expectation doesn't look to be there. Are consulates issuing the 221G for all the cases? No, the consulate is not issuing 221Gs in all the cases, but the consulate is issuing 221G in good number of cases. So I would, if you were planning to travel, I would be very careful. I would consult a lawyer to make sure that you actually have a good chance of getting the H-1B approval. And if by any chance the 221G is being issued, is your end client willing to wait for you to come back, because 221G takes a long time and your end client might not be willing to wait for that much period of time. So you may want to see that if you're going there, is your end client wanting to wait for that much period of time?
So So I think we've stopped receiving.
No, we have it. We're getting it. We're getting it.
Facebook? Okay.
Yeah.
Are you getting some?
Yeah. How many months it takes for a H4 and EAD extension? Right now, H4 extension is taking approximately about 6 to 9 months. So if you file a H4 and EAD separately, it's taking 6 to 8 months for you to get the H4 and plus EAD extension. If you join the H4 and H4 EAD along with the H1B, your chances of getting the H1, H4 and EAD is, if you're filing premium processing, is approximately 3 weeks, and if there is an RFE after your response, it's going to be 6 weeks.
Okay, can we file an H1B extension while the H1B transfer is in progress with the same employer?
Well, I don't know why you are ending up into the situation of filing an extension. And I mean, if you file a transfer and you're
Right,
filing an
doesn't-
extension,
never mind.
that, well, you could be there because if you filed an H1B transfer for 1 year and then you're now filing an extension, you could have done a premium processing. You could have done a premium processing, get it resolved. I don't know why you have not done it. Yes, while the transfer is pending, you could file an extension with the same employer, not a problem. But if the transfer is pending with company B, and now you are going with company C, you will have an issue. We call this company B application as a bridge application. And with company C, if this bridge application is denied, the company C's H1B also will be denied.
Okay, can I travel when I'm on STEM OPT working at a third-party client?
I would advise you not to travel. Now, legally, you could, but the way USCIS is interpreting is that since you're working at a third-party site, you might face an uphill battle coming back into United States at the port of entry. I would advise you not to travel. Will there not be any RFE after September 11th? No, they said only in some extreme cases. I take back my extreme word. In some cases where the petitioner does not file the basic fundamental documents, they will deny. This memo, which is becoming effective on September 11th, is not restricted only to business immigration. It is restricted to all the immigration. And the entire immigration, business immigration, is only 15%. So though it has been populated as if that it's going to be affecting only for business immigration, there are many other immigration. I have went to USCIS many times. I went inside where they open the boxes of the citizenship application. There are people who are filing citizenship application even when they don't have a green card. We'll file an application, we'll see if we get an application or not. Now, in those cases, they are telling the USCIS instead of issuing an RFE, they would deny. For example, if somebody files a H1B right now, and they are subject to the quota, they file, I will try my luck to see if the USCIS approves. They are not, what the USCIS is saying, they're not going to issue an RFP. They might deny it automatically because you're asking when the quota is not available if you're subject to the quota. But obviously, if you don't submit the fundamental documentation that is required, they will deny your H1B. They will deny your H1B application. But if you submit the basic fundamental documents, you should still be getting the H1B adjudicated with the RFP if necessary.
Okay, let's see.
Just in case if you can't get through any of your questions, guys, you can always make an appointment with rnlawgroup.com with me or any of our 14 colleagues. Please log into the Immigration Girl website. Please log into RN Law Group and also come to Facebook Live and YouTube Live. Today is the first time that we are on YouTube Live. But we will be coming every week with the questions and answers. We'll try to address as much as questions that you post in the Facebook. We do have a daily conference call also where we can come and ask the questions too. Any more questions coming up from Facebook?
Is there a new date for the H-4 EAD revision?
When you say H-4 EAD renewal, I'm assuming that H-4 renewal is right now allowed. H-4 renewal, you can do it, absolutely no problem with it. H-4 renewal may be taken off at a later date. The major question that pops up is that when they take the H-4 EAD off, will they withdraw all the existing H-4 EADs? Now, they haven't come up with a proposed regulation yet. Once they come up with a proposed regulation, we might be able to clarify the things a little bit more better way. But what we have noticed historically was that when they have taken the EADs for the 900,000 dream kids that we call it, those kids who came into the United States, these kids have fallen out of status, and Obama administration allowed them to give an employment authorization document for them. The Trump administration, when they took that EAD off, they said the further extensions will not be given, but the existing EAD applications will be active. They can still work on the existing EADs. Now, when and if the H-4 EAD is going to be taken off, we are expecting that this administration will treat the legal immigrants with the same courtesy what they have treated the people who are out of status.
Okay.
Questions coming in Indian language.
Do you think that they're going to extend the amount of STEM OPT given due to the amount of H-1B denials?
STEM OPT, what? STEM. Oh, will they extend the STEM OPT for the 24 months? Now, it depends on the university at this point of time. Now, we are getting a lot of RFEs on the STEM extension issues. Some of the universities are not issuing the 983 that will allow you to file on top of your 12 months of OPT, the 24 months. We have not seen the 765 denials yet, Paloma. We may be seeing, but we have not seen yet. But that's a good question, though. There is a good chance that the USCIS might actually deny the 765 applications when you are working at third-party site. So if you're working at third-party site and if you can get to the employer side, you have two job offers, one at a third-party site, one at a direct client. I would recommend that you go to the direct client, though. What are the chances of me getting an NTA? If the H-1B extension is denied and my I-94 has expired? At this point of time, I don't think so, but we will update you if and when any NTAs are being issued. As Paloma was pointing out, there's a lot of fake news going on that NTAs. Please log on to immigrationgirl.com with Emily Neumann. She updates that information. So if you can go there and check that fake news, that would be very good.
Okay. Instead of India, if I go to a different country, such as the West Indies for stamping, will that be safe? I do not want to receive a 221G.
If you do not want to receive the 221G, don't leave the country. I mean, it's like this. You want to bang your head, you want to bang it with a grenade, or you want to bang your head with a marble stone. I mean, for me, it's the same. 221G getting issued either of the places is not good. If you're eligible to go to the contiguous countries, you can go there, but you still have a higher risk there in getting the 221Gs under this administration. Which consulate is better for you to approach? I mean, there's no clear answer to that. What we generally say is that if you have a degree in India, do not go to any other place other than India. If you do have a master's degree in USA, then you can take your chances in Canada. If you're eligible in Mexico, maybe Mexico or probably Jamaica, it's up to you to take the chances though. But if you have a degree in India, do not go to any of these consulates, because the US consulates in India can authenticate the degree much better than the consulate in Jamaica or in Canada. Any other things? Well, thank you guys for logging in. Sorry, Emily could not be here, but she'll be here next week. But if you have any watch any of the news that is coming up. Thank you guys.
Thank you.
Thank you. Thank you, Paloma. Thank you.